Excellent. Welcome, everybody, to our webinar on U.S. versus Rahimi. As you can see, our subtitle here is Dangerous Implications for Survivors and Communities. And what we're hoping to do today is to give an overview of what's already happening in the case, and then hopefully give you some insight about what may happen in the future. We are going to leave some time for questions at the end, live questions if we can, but please do use the Q&A box. I will be looking at the Q&A box, and will try as best as I can to bring those in real time. We're going to do introductions in just a second, but first, hold on. Yes, I want to say a thank you for our sponsors. The idea for this webinar was brought up through the Commission on the Status of Women, Alameda County, California's Commission on the Status of Women. I sit on that commission as the treasurer, and our role is kind of an oversight role for the county, and also public education and awareness. So this webinar is part of that. I do just want to give a little side note. It was very exciting. In early 2024, we're going to be working on a CDAW ordinance for the county of Alameda. More about that later. And CDAW is the Convention on the Elimination of All Forms of Discrimination Against Women. Our co-sponsors, our Family Violence Law Center, where I work as an executive director, and Family Violence Appellate Project, where one of our panelists works, and FVAP, Family Violence Appellate Project, was kind enough to make sure that California attorneys have access to MCLE credit for today's webinar. So thank you to FVAP, and more on that at the end. Okay, our presenters, I just want to say before, they're going to introduce themselves, so I don't mess up anything in their bios, but I do want to say that the way this conversation came up at the Commission on the Status of Women was just really thinking about how many amazing national experts and statewide experts we have right here in the Bay Area, in our own communities. And even though we're doing this virtually, where we probably could do it in person since folks are close geographically, we really want to highlight the expertise that's just right here in our own communities. So both of these folks have deep expertise in domestic violence law, in gun violence law. So I'm really excited that they were both available to join us today. So first, we're going to go to Julia, if you want to say a few words about your background.
Oh, sure. Thank you, Erin. Thank you so much. It's a pleasure to be here with you and with you, Corey. Julia Weber, and I'm an attorney. I'm a social worker. I was with the Judicial Council of California from 1999 to 2017, where I served as co-counsel to the Family and Juvenile Law Advisory Committee, and then transitioned to consulting and worked with Giffords Law Center to Prevent Gun Violence, which is based in San Francisco, was established as the law center after the 101 California shooting, where I knew someone, an attorney who had been killed in that shooting, followed the work of the center as it merged with Gabby Giffords' organization, former Congresswoman, gun violence survivor, and advocate for gun safety laws that reduce harm, and have had the pleasure of then consulting with them since I left to do full-time consulting in January of this year, after working also with the Battered Women's Justice Project at the National Resource Center on Domestic Violence and Firearms. And so I work on the intersection of family law, child custody, domestic violence, and on gun violence prevention policies nationally, and have drafted a lot of legislation, some good recent legislation that I'm very proud of, along with folks who a lot of us on this call, both as panelists and participants, work with as well. So it's an honor and a pleasure to be here. So thank you very much.
And Corey.
Thanks. Yeah, thank you both as well, and to the commission for organizing. My name's Corey Hernandez. I'm a senior managing attorney at FAP. Use they them pronouns. FAP is mainly based in California here in the Bay Area, but we're statewide, and we've also recently expanded to the Washington state. We're a nonprofit focused on appealing for free, dangerous decisions on behalf of survivors of gender based abuse, including domestic violence. Um, and the rest of the bio you can see I used to work at FELC, so it's great to work with Aaron again and to see so many of my former and current colleagues on the call. That's awesome. Yeah, so just really excited to be here and to talk with you all.
And I realized I do this all the time. I didn't introduce myself. So sorry. I talked about my work, but didn't tell you my name. So my name is Erin Scott. As I mentioned before, I'm the executive director at the Family Violence Law Center, which is based in Oakland and serves all of Alameda County. There's more in my bio here, but basically, well, I actually was on the Family Violence Appellate Project board just to talk about how intertwined we all are. For quite a long time in the beginning of the organization. And it's really exciting to have seen that grow. But yes, I've spent my entire career working with survivors one way or another. And I will be lightly facilitating today, since I'm sure not much will be needed. So let's get into it. Just first, a little background. Julia is going to kick us off to set the stage. And I do want to acknowledge, so we are offering MCLE credit for California attorneys today, and there are quite a few attorneys on the call, but we also have folks who aren't attorneys on the call. So, there'll be a couple moments here or there where we're going to, make sure that we're spelling some things out that if you didn't go to law school, might not be intuitive to you. But also, please use that Q&A box if there are things that we're saying that make absolutely no sense to you. And then for the legal nerds among us, whether you've been to law school or not, there is an extensive package of handouts that will be mailed to you afterwards with lots of amicus briefs, lots of case law, some legislative pieces, an article Julia wrote. So just know that all that is coming later if you want to dive into this more. So Julia.
Sure. Thank you, Erin. So a little bit of background, and this is a complicated, extensive topic, and I appreciate having the time we have, but I'm going to acknowledge from the beginning we likely won't be able to cover everything we want to cover. So we're going to do our best to and probably go faster in some respects, and we'll do the best we can to get allow some time for questions as well. So we want to make sure we get to what people are thinking about today, because this is a ever-changing subject as well. So U.S. versus Rahimi has received a lot of attention, of course, recently with the oral arguments just happening here November 7th. And so we're going to back up a bit, and I'll just describe what happened at the lower court level. This was initially a case involving Mr. Rahimi and a woman who is a mother of a child that they share in common. She went and through the family court process in Texas and sought a what we would call in California domestic violence restraining order, also known as a protective order. Those terms are used interchangeably nationally, but specifically in locations, one or the other usually makes sense, or order of protection. And he agreed to the order. Texas has a state law that includes a firearm prohibition under those circumstances. So he became prohibited from having firearms under both state law and federal law. As is the case, and we'll get into this a little bit more, those prohibitions in many jurisdictions around the country are limited in their application or implementation. Unfortunately, many of us would like to see those policies reinforced at the time the prohibition goes into effect. But in general, it's just something on the order that says you shall not have firearms. And unfortunately, very little is done to make sure that those who currently own firearms at the time that they agree to the order is put into effect, that they actually get separated from the firearms they have. He subsequently engaged in a number of acts of public violence involving firearms, shooting up a Whataburger restaurant, shooting up a car accident scene, shooting at a constable, government official's car, and was arrested. Law enforcement obtained a search warrant for his home and found firearms. And he was subsequently charged by federal prosecutors for having firearms in violation of the civil restraining order that he had agreed to. He initially appealed his conviction, in part based on that conviction, and lost. So his conviction was upheld with respect to the firearm prohibition violation. And then after a decision called Bruin, that again I'll talk about in a slide or two, he appealed again, and his conviction with respect to the firearm prohibition conviction, having a firearm in violation of the civil domestic violence restraining order, was struck down by the Fifth Circuit Court of Appeals. So the issue that was before the U.S. Supreme Court, or is before the U.S. Supreme Court, and was heard at oral arguments, is a question of whether this prohibition, which is known as 18 U.S.C. 922 G8, whether 18 U.S.C. 922 G8 is unconstitutional. And that is the prohibition under federal law that says you can't have a firearm if you are subject to certain types of domestic violence restraining orders. And they have to meet certain definitions of domestic violence, includes physical violence, and it has to meet the relationship definition. And that federal prohibition is narrower than the California prohibition. But nonetheless, he met all of the qualifications for not having a firearm under federal law and was convicted, and then had that part of his conviction overturned by the Fifth Circuit. So the question is whether or not 922 G8 is constitutional or not, to whether Congress had the ability to enact a prohibition against someone having a firearm when they are subject to a domestic violence civil restraining order. So next slide, please. So under the Bruin case, there are a couple of tests that I'll talk about in a moment. Prior to Bruin, we had the Heller case, which was a U.S. Supreme Court case that further defined what the Second Amendment rights and limitations are. And in the Heller case, this quote I think is important just to note, 2008 case that Justice Scalia noted in the opinion, that the Second Amendment, despite some sort of generalized sense of, we're entitled to have firearms in the United States, there are limitations on the Second Amendment and this right to bear arms or to keep and carry any type of weapon. Heller was a landmark decision insofar as the kind of individual right to have firearms that it bestowed on folks under the Second Amendment. But it's important even under Heller to understand that there are limitations. This is not an unfettered right. And the litigation that goes on in the Second Amendment space is really about what kinds of burdens or restrictions can be placed on the Second Amendment right. Now, next slide, please. So just to put this in a little bit more context, as I mentioned, 18 U.S.C. 922 G is the section that we're talking about in terms of individualized prohibitions. People can become prohibited for all sorts of reasons. Some of these prohibitions date to the late 30s. Others are reinforced or new under the 1968 provisions that Congress enacted, and still others came about in 94, 95 with the Crime Control Act. But this is the list of who and how you can become prohibited from having a firearm under federal law. And I've highlighted here in yellow the sections that are most relevant with respect to intimate partner or domestic violence. So under under 18922 G1, if you're convicted in any court of a felony, that's what that's about, nonviolent felony or violent felony, you are prohibited. And that's actually a lifetime prohibition. A fugitive from justice, unlawful user or addicted to any controlled substance. Many people don't recognize that or don't realize that this includes marijuana use. The Alcohol, Tobacco, and Firearms ATF have clarified in recent years that even if you're in a state where marijuana use is decriminalized or legal, you cannot own a firearm. You are prohibited if you are a user of marijuana. So if you're an unlawful user, prohibited from having a firearm. The number 4, with its offensive language, again dating from decades ago, talks about basically what is referred to as a mental health prohibition. There are very specific rules around that: admitted, evaluated, and held. This is a situation, again, when a lifetime prohibition is imposed. Again, number 5 here, we're talking about immigration status, despite, again, the offensive federal language that's used there. And you can see 6 and 7. What we're talking about in Rahimi is G8, subject to a court order restraining the person from harassing, stalking, or threatening an intimate partner. That only applies during the time period that the order is in place, so it's not a lifetime prohibition. Number 9, convicted of a misdemeanor crime of domestic violence. That is a lifetime prohibition under federal law. Federal law, of course, has to intersect with state law. California, we have broader prohibitions in the domestic violence civil restraining order space. So G8 is more limiting than our law. We prohibit at the emergency stage, the TRO or temporary restraining order stage. At the order after hearing stage, we also have the ability to extend restraining orders for a longer period of time. The federal law doesn't cover that directly, but the federal prohibition would apply while the order is in place. And we have a broader definition of what relationships count, and we have a broader definition of domestic violence. So you can get a restraining order for disturbing the peace. Coercive control may or may not involve physical violence, but in California, that would result in a firearm prohibition, whereas one could argue that would be less likely to result in a federal prohibition. And then similarly, 9, actually, we have some restrictions in California that are narrower than the federal prohibition, but 8 is the star of the show for Rahimi. So next slide, please. So when the Fifth Circuit struck down the Rahimi decision, it struck down Rahimi's conviction, it was a challenge that many of us in the field were very concerned about. And I was part of a group of people that sought writ certiorari. We wanted the Supreme Court to take up the Fifth Circuit decision for a lot of reasons. First of all, the Fifth Circuit decision only applies in Texas, Louisiana, and Mississippi. Both Texas and Texas and Louisiana have state prohibitions. Mississippi does not. So as soon as the Fifth Circuit decision was issued in February, that meant in Mississippi, there was no way to limit someone with a domestic violence restraining order from having a firearm, which was, of course, of great concern. And in Texas and Louisiana, there was enormous concern about how the state law would be implemented given the restrictions from now that the federal law had been struck down. And then, of course, nationally and in California, we got a lot of questions about how that Fifth Circuit decision would apply. So we also felt strongly that it was a good set of facts for upholding 922G8. And so wanted the Supreme Court to hear the case. And obviously, after those petitions were filed, the government requested the case to be heard, and many advocates did as well. They agreed to go ahead and take the case. What happened at the Fifth Circuit level was this issue of the Fifth Circuit was asked under the Bruin decision whether or not this was constitutional, and said it wasn't. The Bruin decision imposed a 2-part test. And the first part of the test is, does the prohibition burden an individual's Second Amendment rights? And the Fifth Circuit said, yes, in fact, Mr. Rahimi's Second Amendment rights were burdened. He could not have firearms and was convicted for having firearms. The next part of the question is the regulation that burdens that person's Second Amendment rights grounded in the history and tradition of our constitutional law in this area? And the Fifth Circuit said, no, this is an outlier. They looked at the various examples that the government provided, that the federal prosecutor provided, and that the lawyers involved in the case at that point provided, and said, no, none of these count. None of the analogs, the similar situations, are similar enough. And one of the things that's happened with Bruin is that federal courts are being asked to act as historians. And lawyers are being asked to present information or evidence as historians. There are a lot of questions about whether or not the absence of a regulation suggests that, in fact, it was permitted or disallowed. There's evidence that during the Plymouth colony, there was regulation of domestic violence, even when there was coverture or legal permission to beat your wife or to use corporal punishment to correct or modify her behavior. Even in the midst of that kind of misogyny, the inability for women to vote or participate fully in civic life, there is some suggestion there was some regulation. There is no example that anyone's ever found of a regulation that says that you cannot have your musket if you engage in spousal battery or otherwise restricted by a civil restraining order. So an exact match isn't available. And next slide, please. In the Fifth Circuit decision, there was a concurrence by Judge Ho. In Judge Ho's opinion, he goes through additional reasons why this prohibition should be found to be unconstitutional. He is very disparaging of civil courts, believing that family courts, civil courts do not employ due process, that they don't take evidence, that they basically hand out orders of protection or restraining orders like candy, that if these cases were in fact really dangerous, they would be in criminal court where there would have been an arrest, a prosecution, and incarceration, so that civil court doesn't really reflect the level of dangerousness that would warrant a firearm prohibition. And he found all sorts of examples that, in his view, demonstrated that civil domestic violence orders or court proceedings are used by women to get a leg up in custody battles and to make baseless allegations. And that judges just hand these out without any kind of process involved. This was an additional concern to many of us who spend time trying to build up public trust and confidence in the system, and who also have a well-grounded understanding of how imperative it is that we have civil proceedings that do handle very dangerous cases, but that provide an opportunity to survivors to steer the case, especially in light of some of the discrimination, marginalization, and experiences that too many survivors have had in the criminal legal system, especially in domestic violence situations. So that's the background. They struck down his conviction under 922G8, saying it did not have any kind of support, that Congress did not have the authority to pass that kind of regulation because it was not well grounded in the history and tradition of our constitutional law. And I'll turn it over to Corey.
Thanks, Julia. That was really great background and great groundwork for all of us. I think Judge Ho's concurrence is particularly interesting because a lot of us on the call who are advocates and attorneys working in the family law system know just how not true that is, especially even in California, where a lot of people say we have, maybe very broad definitions of abuse and, much more lax procedures and stuff. it can still be quite difficult to get a restraining order for a variety of reasons. And I think there is that common misperception that they do just get handed out pretty easily. If that were the case, FAP maybe not even need to exist, right? So I think that general misunderstanding of family law sort of pervaded my view of the oral argument that happened last week. I'm sure a lot of people on the call already watched it, so I apologize if I'm just summarizing something you've already heard. Hopefully, I can offer maybe some of my insights, not as a Supreme Court expert, but just more somebody who follows them really closely and is very interested in this case. So as I said, in general, I saw during the oral argument not understanding family law, not understanding the state court systems. There are a lot of questions, especially toward the end, about what actually was found in this case in the underlying restraining order proceeding, particularly because, as Julia noted, that was entered into by stipulation. But I think there was a missing element that that stipulation, a court in general can't accept a stipulation if it's against public policy or doesn't have evidentiary support in the record. So I think the stipulation basically should be treated just like an order after a hearing, after an evidentiary hearing, and hopefully that isn't, one of the turning points for the court. But just kind of going through the different justices and sort of where they might land. I'm sure if people haven't, there have been a lot of articles and blog posts about the oral argument. In the slides that we'll send out, we have the presenter notes at the bottom. We have some links to some articles and stuff you may want to check out that kind of talk a bit more about what happened and what they may decide. To let you know, this is one of the big profile cases, so we're not expecting a ruling for some time, probably not until June of next year, as they're wont to do. And of course, we'll have to ultimately see what their reasoning is before knowing how it may apply to other areas. But after I do this slide, we'll kind of talk through what could happen in future issues. But one of the highlights during the OA I thought was particularly noteworthy were at least two of the justices, Jackson and Kagan, seemed particularly concerned about the scope of Bruin and whether that historical analog test is itself actually a test. And if it is, if it's an appropriate test for something like domestic violence, as Julie was talking about, that was treated very differently historically, and given the relative, novelty of civil restraining orders. And, even one of the more, in that group of more liberal justices, Justice Sotomayor, interestingly, the only substantive question I noted from her was sort of understanding whether the test is a sort of equates responsible person with somebody who's not dangerous, or if that's actually two separate categories of persons. And a few of the more conservative, more moderate conservative, I guess now in this conservative court, justices that, from my point of view, Gorsuch and Roberts, seemed very focused on the fact that this is a facial challenge, not an as-applied challenge for Mr. Rahimi or a different defendant, which is important because for those non-attorneys on the call, the difference in that type of constitutional challenge is basically that a facial challenge challenges the statute in its entirety in all of its applications, whereas an as-applied just challenges the constitutionality as to one particular person. So I think those justices, and even Justice Barrett, seem to understand that there are at least some instances where this type of federal firearm prohibition would be constitutional if it is based on dangerousness. And I think a lot of the argument was focused on these more outlier questions, these other hypotheticals that we'll talk about later. But I think kind of refocusing those three justices in a sort of more middle, kind of try to focus in more on what this actually is. And interestingly, even Chief Justice Roberts, at one point when the respondent was arguing, got the respondent to concede that it actually could be constitutional sometimes to disarm people who are deemed dangerous, even in civil proceedings. And there was a great question that Chief Justice Roberts asked, which is why that just doesn't end the case, right, against them, and lead to reversal. So I think that's why a lot of people who have listened have sort of their sense is that the justices seem very wary, right, of affirming and agreeing that this is unconstitutional. On the more sort of three more conservative justices, again, from my point of view, I think Justice Kavanaugh seemed a bit more concerned just about the practical application of either ruling, whether affirming or reversing. In particular, towards the end, he focused a lot on background checks and if, whether they affirmed, would this just end all background checks going forward or for a significant number of people, and seemed to very concerned about the potential implications for public safety. So, although he's traditionally been a bit more conservative, that could, again, as a facial challenge, lead him maybe to reverse. Justice Alito, from my point of view, seemed a bit more concerned about the language used, wanted it to be very narrow, seemed very focused on felonious conduct and similar sort of conduct. On the much further side, Justice Thomas, I think, has already made his point of view clear, in my opinion, on this issue. For those who don't know, there was an earlier case, Voisin versus United States from 2016, which is going to be in that package of handout materials we'll send out. But in his dissent there, Justice Thomas, that case was about 922 G9, which Julia talked about, which is the misdemeanor conviction for domestic violence. But in his dissent, in the part of the dissent that was not joined by Justice Sotomayor, she joined the rest of it, but not that particular one. He specifically expressed concerns about the constitutionality, but in doing so, basically said that he would not find it constitutional, and kind of suggested that most of 922G might be unconstitutional. So I would be personally just quite surprised if he were, changed his point of view dramatically from that point. But yeah, so as I said, we have the oral argument link in the slides for people, including to a version where you can actually see who's speaking as you go through the oral argument, which I think is really useful, as well as some, articles about it. And yeah. And I think now we're going to turn to the analysis and like what they could do if they affirm or reverse.
Yeah, so before we get back to our experts and their analysis, this is just a reminder both for the non-lawyers, but also for those of us who went to law school and never want to return to it. Just a quick reminder that here are the Supreme Court's two options. So they can agree with the Fifth Circuit Court of Appeals that the federal law that we've been talking about violates the Second Amendment. Or they can disagree with the Fifth Circuit Court of Appeals and find that the federal law doesn't violate the Second Amendment, which, seems kind of simple, like it either does violate the Second Amendment or doesn't. But as we're going to kick off here in analysis, how they decide that, the language that they use could have lots of different implications.
Yeah, thanks, Aaron. Yeah, their language is, of course, going to be crucial both either way, definitely. If they affirm, here are some, additional questions that we think folks should be considering when they're doing future litigation. So one is, would lower courts then have to or be allowed to find other state civil domestic violence restraining order laws constitutional? As Julie was mentioning earlier, California's prohibition, which is in Family Code Section 6389 for domestic violence restraining orders and other civil orders, is much broader. It applies to all domestic violence restraining orders. It applies to many other types of civil orders in certain factual cases. And since at least 1998, California has recognized as part of the definition of abuse a lot of non-physical conduct that isn't necessarily recognized by federal law, including harassment, disturbing the peace, making annoying phone calls, stuff like that. And so, the federal prohibition, this came up during oral argument too. The part of the petitioner's argument for why it is constitutional was that the restraining order, at least in Texas, could only be entered after the court found danger was present and expressly found that the restraining order was needed to prevent further abuse and that there was a likelihood of further abuse without the order. And the petitioner specifically argued that that was sort of a basis of all injunctive relief and sort of basis in equity. And that is generally true for how injunctive relief works, federal law and most state law. And in other California civil restraining order context, that is required, like a civil harassment restraining order under Code of Civil Procedure 527.6 or workplace violence restraining order 527.8. But domestic violence restraining orders under the Family Code and elder abuse restraining orders actually have case law that expressly says those two things are not required before you get a restraining order in California. So you don't need to prove danger is present or would be present without the order. You don't need to prove that there is a likelihood of future abuse. And there is some case law in the presenter's notes that talks about that. So those, again, however the Supreme Court goes, given the different statutes and the procedures that California uses versus the federal laws, I think there's going to be a lot more litigation coming our way in this scope. Unless, of course, the Supreme Court just, if they were to reverse and use some very broad language that sort of allows any of these types of orders. But also wanted to mention, so there are, outside of even the restraining order context, if they were to affirm, would their reasoning extend to other types of restrictions and other civil or family law actions, like declaring somebody mentally incompetent? California recently started the new care courts, and like there's all these other types of civil actions that may result in somebody having restrictions on their firearms, or even in family law, given how broad family judges' discretion is, their authority, what they're allowed to do, and how broad the concept of best interest is, there could potentially be an argument that even if they were to affirm, maybe on a case-by-case basis, in certain cases where it's particularly egregious, the family court or a civil court could still order it if they make certain findings, right? If the Supreme Court's reasoning in the case says it's unconstitutional because they don't require certain things, then if a future court were to do those certain things, maybe it would be constitutional. So there are, I think this is one way of saying, like, even if they affirm and they agree that it's not constitutional for whatever reasons, there may be other avenues for protection and for restricting firearms. And we'll talk about some of those later as well. But yeah, I think now, Julia?
Thanks, Corey. I would say I would just like to add next slide, please, Aaron. That if they were to affirm, again, I think, Corey, you're right in terms of how broad or narrow, of course, they make the determination. I was involved with several amicus briefs that were filed based on the merits. So subsequent to them taking up the case, then many of us worked on various ways to communicate with the court about our sense of why they should overturn the Fifth Circuit decision. And I think, the greatest concern that we were getting at in various ways is certainly with respect to domestic violence, the dangerousness associated with affirming this decision and the implications nationally. Because, and I think as Justice Coney Barrett pointed out, there would not be a lot of avenues. It's likely that if they were to affirm and say Congress did not have the authority to enact 922G8, then again, depending on how broad their reasoning is, it would be hard to imagine that the other civil prohibitions, and in California, civil harassment orders are firearm prohibiting, elder abuse orders where there's physical violence or firearm prohibiting. The gun violence restraining order, of course, is also firearm prohibiting. School violence prevention orders, workplace violence orders are all firearm prohibiting orders. So we have a broad number of civil orders that are firearm prohibiting in California. And the question would then become whether any of those could be, withstand Second Amendment scrutiny. So lots of concerns. Now, if the Supreme Court reverses, and no one likes to predict what the Supreme Court will do, this one in particular, but there is a lot of optimism. And my article speaks to why, under the Bruin test, I believe, and there are many other scholars in support of this view, why we believe that under the Bruin test, which is a very difficult test, lots of problems, as Justice Jackson and others during oral arguments pointed out. But even under the Bruin test, the Rahimi court made the wrong decision, is the argument that many of us make. And the hope would be that this Supreme Court would use the Rahimi case to help refine the Bruin test, make it more practical as best as one can, given its problems. But that we have, in my view, a long history of regulating dangerousness when it comes to firearms, a history that dates actually to the early part of the development of this country, where when dangerousness was recognized in terms of the public order. One of my favorite examples or analogs is the going armed laws that talk about limitations on someone being able to carry firearms when they're taking them out in public and waving them around, and going armed in a community and creating unrest and fear and being perceived as dangerous. So recognizing the dangerousness when someone has firearms to the community, as well as in their home. And that's something else, if we have time, we'll get into. There's such a heavy emphasis in Second Amendment law around being able to have a gun in your home so that you can protect your safety, which of course, for all of us who work in the domestic violence space, is ironic and also ridiculous and frightening, because that is often where intimate partner violence occurs, and the home is not a safe place. And so maintaining firearms in the home is particularly dangerous for domestic violence victims and survivors. So if the Supreme Court reverses, which we are all hoping they do, and that they overturn the Fifth Circuit decision, the question will be how broad or narrow, again, similar to the affirming issue, and whether or not we would be looking at sort of greater support for the kinds of limitations that California places in those different categories that I just described. So if they reverse and say it's constitutional for Congress to have imposed this prohibition, we could hope that it's broad enough to support legislative action at the state level as well, that restricts access to firearms. We could hope that it would be broad enough to support nonviolent restrictions on access to firearms to some extent. They were not asked to, and it wouldn't necessarily be appropriate, and it's unlikely that they'll get into the nonviolent felony or the misdemeanor crime of domestic violence or the mental health prohibition. But this is not the last of the Second Amendment litigation cases. And so the reasoning is going to be significant, because ultimately the question is, under what circumstances can our state legislature and our federal legislature, Congress, regulate access to firearms? And what kind of historic precedent and analysis is appropriate? One of the things in Bruin, Justice Thomas said, you don't need to have an exact match. Thomas wrote the opinion. He said, you don't need to have an exact match. It's a matter of what's similar. So if you have a green hat and a green truck, are those two things similar because they're both green? Or are they different because one's a hat and one's a truck? So that's what our courts are being asked to do, is figure out what's the same and what's different, which is a lot to ask for folks who are not well grounded in history, and given how history is not static as well, as we learn and uncover other aspects of it. So we are hoping for a reversal, and we're hoping for a reversal that includes enough analysis that we can be looking at defending other Second Amendment restrictions so as to reduce dangerousness fairly and appropriately across the country.
Yeah, and so I think next slide. Thanks. Actually, I think the one before that, Aaron. Sorry. Uh, but next couple slides, we'll talk about sort of future issues. So whichever way the court rules, these are some additional things that additional issues that will need to be litigated. So for folks to keep in mind, especially for those practicing in the trial court or helping people at the trial court, just to help make sure that there's a proper record, issues are preserved for appeal. If you have questions about how to lay a record to preserve that, you could see FAP's website. We have trainings for advocates and attorneys to help them help their clients. But so,
Corey,
oh yeah,
sorry, just a sec before you go on. I know we've had some hands raised. I
oh
am asking people to hold their live questions and to please type them into the Q&A for now. And if we have time at the end, we'll go to live questions. Thanks.
thanks, Aaron. Yeah. And I think I don't want to speak for. I can stay on a little long, a little past 4 if folks want to talk. And we also have our emails at the end, so folks can email us to chat further. But one thing, as Julia was mentioning, we will definitely see a lot more litigation on what exactly this test is in Bruin, whether it is a test, right? Justice Barrett seemed to think it was just a version or sort of like the category that applied in that case, but it wasn't the test for all Second Amendment challenges. So it's unclear exactly. And of course, she wasn't on, some of these newer justices, right, are coming in like Jackson are questioning it. So I think it'll be really interesting to see where they land. And again, we'll have to see where it is, but I'm guessing this is going to lead to a lot of separate opinions in my point of view. So it'll be really interesting to see how everybody views these issues. And then there's some of the oral argument and some of the briefs also focus on these due process issues that people perceive in civil restraining order or family law contexts. Whenever that came up during oral argument, I think some of the justices like Gorsuch or Sotomayor kind of did a good job of refocusing on and making sure to say, well, that's not really this case, though. That's not what happened here. So, but I think the fact that those are issues and questions coming up show that they are going to persist. And the basic idea being that a lot of people think especially when it comes to domestic violence or gender-based abuse against women, that there need to be these sort of special or heightened protections because of misconceptions, mistaken preconceptions about how frequent false reports are and things like that. And given, as Judge Ho's concerns in the concurrence stated, they think that these restraining orders are just kind of handed out. But we saw a very similar vein of argument that's been working in the Title IX context. For those who don't know, that's a federal law that prohibits sex discrimination in secondary in education, post-secondary and below, which includes sex discrimination has been held to include sexual violence and domestic violence. And so whenever a student accuses somebody else, like on a college campus or K through 12, they usually then go through a misconduct hearing, often called a Title IX hearing at the school, administrative hearing, to determine whether or not the conduct occurred, and then if so, what sanction is appropriate. As many people know, there have been a lot of litigation, mostly by respondents in this area, that has led to cases saying that in Title IX misconduct cases, they have to have a lot of these heightened like evidentiary rules. They basically think that they have to look a lot like criminal cases to have those special protections, what they think is due process. Fortunately, in California, earlier this year, we had a state Supreme Court decision, the Bormeister versus Carey decision, that kind of helped put an end to that a bit in California by saying basically that you can't require more for certain types of misconduct than others, and you have to apply the same sets of rules. So I think that's going to be something that's going to be coming up a lot more, as noted here. Some of the amici briefs here in the Rahimi case at the U.S. Supreme Court also raised a lot of issues on that. And then on the next slide, some additional issues that will be raised or need to be considered. One is 14th Amendment Equal Protection Clause issues. So that's another constitutional amendment that grants people certain rights or certain basic fundamental freedoms. And there, we had a recent case here in California, a state appellate court case that was partially published, and the part that was published specifically found that our state prohibition, Family Code 6389, does not violate the Second Amendment, even under Bruin. That reaffirmed a prior case, Altafulla versus Irvin, which was decided in 2015. So that was decided based on the Heller and McDonald cases from a couple years ago. But they kind of just reaffirmed that. So that's very useful. And they addressed this other argument that it doesn't violate the 14th Amendment by treating certain people differently by allowing some people to have exemptions to the firearm. So, California in Family Code 6389 has a specific exemption allowed in subdivision H for people, certain restrained parties who need it for employment and other requirements are met for the trial court to grant that exemption. This Zachary H case in California found that distinction is rational and doesn't, violate the Equal Protection Clause by treating certain restrained parties differently. But on the sort of second issue, federal preemption, because California does have that exemption and federal law does not in 922G, that is still ripe, I think, potentially, for a constitutional challenge, mainly from the protected party's point of view. If in particular, if say a restrained party were granted an exemption, technically, in my view of the federal law, they would still be, subject to that, even if California granted them an exemption. And so the protected party could potentially appeal that as an issue of federal preemption and try to get that exemption taken away. And then lastly, another issue that was again brought up during our argument in the briefs is how long these restraining orders last. Because one of the key things the petitioner kept pointing out, and I think some of the justices were really buying into, was that this restriction is only in place for as long as the restraining order is. And most state restraining orders, across the country, are only for a limited amount of time. Usually, some states, up to a year initially. Others maybe up here in California up to 5 years. But there was a question during our argument that the petitioner was not able to really answer, which is, what about permanent restraining orders? Because California and I think a couple other states does allow that at the renewal stage. In particular, if the restraining order has been really effective and is doing what it needs to and it needs to be extended, or if it's been violated and the restrained party shows that they need further orders for protection for the protected party. Notably, the petitioner during our argument specifically said that they weren't aware of those laws and just so couldn't speak to them. So I think that's just going to be an issue that's going to come up later. Here you'll see Ritchie versus Conrad. That's one of California cases back from 2004, so even before Heller, before McDonald and all that, where a California appellate court it found, in actually that case that held that a court has to impose the Family Code 6389 restriction. It can't just strike it out entirely unless the subdivision H exemption is met. But in doing so, that Ritchie court spent a lot of time talking about how expansive our definition of abuse is and how they, in their view, they thought it was a bit easier to get restraining orders, or maybe too easy. And so they sort of questioned, why the firearm prohibition applies to these non-physically violent cases and stuff. But there wasn't a direct constitutional challenge like here. So I think, some of the reasoning in that case and maybe what we've seen in the briefs and stuff in this Rahimi case could be used to maybe try to tackle if, say, the Supreme Court reverses. They may find a Second Amendment challenge valid for, say, a permanent restraining order versus a temporary one. So just some future points to consider. I think next slide.
So what I'd like to do now is, just because we only have 3 minutes left, is just ask if there are questions. There are a number of other issues related to custody and visitation, but if there are a couple of questions that we might be able to get to the last couple of minutes, I'd like to do that, Erin, if that's all right.
Sure. Diane, you had a question. If you want to raise your hand again so I can find you easily, if you're still with us. If you want to ask your question. Diane, are you interested in asking your question again? I can allow you to talk now.
Can you hear me now?
Yes, perfect.
I had surgery on my finger, which happens to be my typing everything finger. And so I was trying to turn off the buttons and I screwed it up. So I didn't have a question, but thank you.
No worries, but you had your hand up a couple of times. So
I was trying to turn it off and I'm thinking, well, wait a minute, how do you turn it off? Hey, I'm really challenged right now. So sorry. It was an accident. No, I thought the entire conversation was very informative.
Got
I
it.
really appreciate having it on.
Yeah, no worries. Does anyone else have a question they want to ask?
All right, well, while folks are thinking about it, doesn't sound like there is. So just again, in the interest of time, let me just note that one of the things we wanted to just touch on is what you can do about this, which includes this issue of child custody. I do a lot of work at the intersection of child custody, firearms, and domestic violence. Was part of a group of people with Senator Caballero's leadership and Gifford's sponsorship. Women's Caucus priority this year was SB 599, which we were able to successfully advocate for. The expectation there is that judges will take into consideration when domestic violence and firearms are an issue, whether it's in the best interest of the child to have no contact or supervised contact, including virtual visitation. Lots of things to look at in SB 599, to advocate for, to form a record around, for FFAP's involvement as necessary. We have, of course, 3044, we have 3011, and with 599, greater attention to be paid on not having so-called, I call them so-called supervised visits in unsecured public locations. That's not an answer to reducing risk. The tragedy in Sacramento where 3 girls were murdered by their father, who then turned the gun on himself, died by suicide after also killing the supervisor. That horrendous tragedy was a case in which there wasn't an indication that he had firearms, but of course there were other concerns about his dangerousness, and mom and the girls had time living in a confidential location, but then were expected to go to this location. And we can imagine by looking at the case, and we know that there was a certain amount of pressure to show that you were committed to co-parenting by agreeing to some kind of contact. So virtual visitation, just like we have great relationships over Zoom as colleagues, you can utilize, again, no visitation if it's appropriate, and this kind of contact if there's no resource for a secure location, because he was able to pick up an unserialized so-called ghost gun on the way to that scene and commit that horrific tragedy.
Julia,
So
we do have a question. I know
right.
if you want to
Let's
finish
do
that
that.
thought. Okay,
Yeah,
great.
let's do a question. We'll
Great.
take
So
advantage of any moment we have. Yes.
Yeah, and we still are holding on to quite a few of our attendees, so let's go for it.
Well, Aaron, if I could just, sorry,
Yeah.
I just wanted to know, for those who are leave or may have to drop off, the slides have the evaluation form, which will ask you to complete to get the MCLE credit.
Yeah.
So it's at the last slide. There's a link on there.
Yeah, thank you, Corey. And I'm sorry, I also did want to mention, I did see your note, and that was, you saw my screen going back and forth. That was me trying to copy and paste. I'm just going to send it out to all attendees as well as a link in an email. So apologies for the bit of chaos there. So the question comes from Aaron Smith. If the court adopts a dangerousness test to uphold the law, which it seems like it might, do you think that will mean state courts need to make an additional finding in domestic violence proceedings that the respondent is dangerous if they have access to a firearm?
I mean, my take on that is it's entirely dependent on what the reasoning is. You know, this only deals with the federal prohibition. It doesn't deal, the Texas state prohibition is not part of the case. So it's a matter of how broad it is, both in terms of the substance and in terms of whether or not it's going to talk about state regulation versus Congress's ability and what burdens the Second Amendment right. So I don't think we can predict whether or not they'll expect that. Already, the federal prohibition only applies in cases in which there's been physical violence. So which is more limited than California's, for example. So it's entirely dependent on their reasoning and whether it's limited to congressional action and whether it is a additional requirement beyond the physical violence and whether it's not adequate enough for a court at this point, a state court, the lower level to determine that physical violence and the issuance of the restraining order is evidence of dangerousness in and of itself, which is, of course, what the filings also try to argue. Corey, I don't know if you have other thoughts on that.
No, I think that's spot on. And Aaron, do you think you could just go to the next slide just so folks can see?
Sure.
I
There
don't
is
think there's anything more to say on that, but yeah.
Yeah,
just
there's
wanted
just a comment from Minty in the Q&A just saying enforcement is still kicking my butt. I don't, Minty, I don't know if there's anything else. You can raise your hand if there's anything else you want to say about that. But yes, I think we can all agree enforcement of restraining orders is an issue.
Well, and I would just say that, again, I want to point out, this is really important to me. Rahimi is not a domestic violence case. He was not prosecuted for domestic violence. The way 922 G8 has been used is by federal prosecutors to hang a criminal charge on someone who engages generally in other kind of dangerous behavior, right? So we should not fool ourselves that 922 G8 has been robustly implemented, and that if it were to go away, there would be there's no question it would be very, very damaging. But what is also damaging is if it's upheld and we continue to not enforce it, to not apply it at the time of the prohibition, and to not adequately follow up to ensure that victim survivors who come forward who should be protected by that prohibition actually can take advantage of it. So we in the movement need to work even harder to put pressure on prosecutors to take it seriously, to put pressure on family courts, civil courts to enact it, implement it fully. The other place that we know that it's been utilized is the number of people who have been prevented from purchasing firearms or being issued a license to purchase firearms because they know that they're prohibited and they attempt to buy firearms, and background checks turn up the fact that they are prohibited under federal law. So that's very important, very protective, but I want to see more robust enforcement or implementation, Minty, in this respect, in all respects. But with the firearm prohibition, if we care about 922 G8, we're lucky enough to have it remain constitutional in place. We still have a ton of work to do to realize its potential and adequately, or more effectively at least, protect victims and survivors.
Yeah, I would just add to that at least on the local level, we always hear our law enforcement departments complaining about not having enough resources to enforce the firearm restriction. Whether that's completely accurate or not, I just want to highlight it because I think there's advocacy to be done, on the state, local, and federal level in terms of law enforcement budgets, just making sure that what's in their budget explicitly accounts for this obligation that they have.
And we had $40 million allocated last year in state funding, one-time money statewide for courts and law enforcement to apply. We only had 8 courts apply. They represent the majority of the state. They're the larger courts generally, except for one small county. $40 million in one-time funding for implementation of firearms relinquishment in DVRO cases and GVRO cases, gun violence restraining order cases. We also successfully passed AB 28, which is anticipated to bring in $160 million. That's an excise tax on ammunition, $160 million for gun violence prevention, and specifically domestic violence firearms relinquishment is one of the categories where we're expecting 15 million or more a year ongoing funding for firearms relinquishment in civil cases to reduce the number of armed prohibited persons. So we have some funding. The word has to get out about AB 28. We have to see that fully implemented as well. So stay in touch, and we're happy to work collaboratively with you to make sure these good policies actually are effectuated.
Yeah, I'm gonna just skip past. I mean, this slide is actually pretty robust in terms of comments here, but just want to show this, which Corey's already referenced a few times. All 3 of our emails are here. There's an evaluation form for MCLE certificate, but I will also link to that evaluation form in an email I'm going to send to all participants, all attendees after after this webinar, which will also include that packet of lots and lots to read on these issues and these cases and the Rahimi case, if you are interested in doing more. I think we should stop there. Thank you, everybody. I will also send out the recording if you'd like to review any of it. Thank you very much for attending, and thank you again to our wonderful, wonderful panelists. You guys are the best.
Thank you. Thanks for inviting us, Erin. Nice to see you, Corey, and thank you everyone for taking the time to join us today.